This is Law Bites, a podcast with Michael Geist.
Fair dealing has been a part of Canadian copyright since 1921, and a series of landmark Canadian Supreme Court decisions, in particular in 2004 and in 2012, have outlined the nature and parameters of fair dealing in Canada. In particular, a 2012 decision that applied to works in the educational context. This was coupled with changes to the Copyright Act brought in 2012, which allowed for education to be a unique head in fair dealing, where previously the Supreme Court's decision earlier that year in 2012 had based the same kinds of rights under the heading of research and private study.
Last week was Fair Dealing Week, a chance for a wide range of Canadians, educators, students, librarians, archivists, and creators to celebrate the important role that fair dealing plays in facilitating both fair access and fair compensation to copyrighted works. I ran a series of posts on Canadian education, fair dealing, and copyright that will continue into the coming week. This podcast episode is part of that series, as I'm joined by Stephen Spong, the director of the John and Dotsa Bitove Law Library and copyright officer at Western University. Spong used Fair Dealing Week to write a piece that appeared in multiple press venues, lamenting what he termed Goblin mode gaslighting on copyright. He joins me on the podcast to talk about fair dealing in practice, the ongoing policy debate, and what Goblin mode gaslighting actually means. Stephen, welcome to the podcast.
Thank you for having me.
Yeah, I'm really glad that you've taken the time to jump on. We're recording this on a Friday, coming at the tail end of Fair Dealing Week, and both of us have been active. You've had a couple of pieces that appeared in the London Free Press and the Hill Times, and I've been blogging daily on Canadian copyright, fair dealing, and education. And I'll put links to all of the various pieces in the show notes for this podcast. Now, I wanted to bring you on this podcast to talk a bit about the realities on the ground for fair dealing and how you see the discourse around policy reform. Why don't we start with a bit of a primer on fair dealing? Some people who listen to this podcast will be experts and will know lots about it. Others may be newer to the issue. And as you know, and others may know, the past 20 years or so has seen multiple Supreme Court of Canada decisions involving fair dealing. Can you talk a bit about that evolution?
Of course, yes. Well, as you say, fair dealing has been around for a long time. Really, the where its story begins in the modern context, I think, really kind of came to the fore with the CCH and Law Society of Upper Canada case in 2004, which is the case that brought us the term large and liberal interpretation, and as it was initially applied to research, but then later expanded to all of the fair dealing factors. And it, of course, also introduced the 6-point tests for assessing fair dealing. So that, for those who don't know, I'm sure many of you do, that's the purpose of the dealing, the character of the dealing, the amount of the dealing, alternatives to the dealing, the nature of the work, and then the effect of the dealing on the work. And while the CCH and Law Society case was really, and it remains a landmark copyright case, and really kind of started the story of modern fair dealing interpretation, there was still quite a bit thereafter, and the next sort of major landmark was in 2012, which was saw both the pentalogy, which is what we call the 5 copyright cases that were released by the Supreme Court on the same day in July of 2012. And then there was also the Copyright Modernization Act. And the Modernization Act was significant because it added education, parody, and satire. That was in addition to research, private study, criticism, review, and news reporting. And Well, there were 5 cases in the Supreme Court in the pentalogy. The really relevant ones were the Alberta and access copyright and SOCAN and Bell cases. Well, the Alberta and access copyright case covered a lot of areas. Really, the key takeaway there was that it reinforced the CCH test. And then, of course, the most recent case was the conclusion of the long-running York and Access copyright saga in 2021. What was interesting about that case was that in the fair dealing bulk of that was in the lower courts, but the Supreme Court said that the lower court reasoning was flawed, and that in addition to considering the fair dealing, the nature of the dealing, at the institutional level, they also needed to consider the student interests as well.
You started, of course, with the CCH case, which created that strong grounding, as you suggest, with fair dealing as a user's right, affirmed in the pentology in 2012, where you get the court taking a look at some of these issues, and again coming quite strongly in favor of a large liberal interpretation when it came to fair dealing. But for whatever reason, there were some that still doubted what the court had said. And the access copyright case with York University played out over a number of years. Some suggest there is some amount of uncertainty. I must admit, I'm not in that camp. I think that we have now seen successive Supreme Court of Canada decisions, as you've described. We've seen a turnover in the bench. And so it's not that this is about a single judge or a couple of judges. This is now justices that have changed over time, and yet the consistency with which they've examined copyright, particularly with respect to issues around user rights and fair dealing, has been very consistent, despite the regular number of cases that we've seen. There are those that suggest that the door is still open. Is it because of that case? Is it because other parties just are hoping against hope that some court or some government will simply take it upon themselves to re-examine the state of the law? How do you account for at least some groups trying to, I think, sow ambiguity into the area?
Well, I mean, I think that I think that the term that you use is a good one, which is to kind of hope against hope. I think that frankly, for those who like, and access copyright, I think is the big boogeyman, if you will. I think that for them it is existential to a certain extent in terms of what their business model is. And so they need to be able to grasp anything. And so while I think that it is the language in Access and York is, as you say, quite strong, I think that there's enough there. That they're clinging to it to hope against hope. And the thing that I find somewhat curious about it is that I had hoped that following that, and I know that discussions that I'd had with colleagues at other institutions had been that perhaps this would be an inflection point in Access Copyright's business model, that they might say, okay, well, you know what, we've run out of road on this. We're going to change to doing transactional licensing or rebrand or find something. Try to be more constructive. Say, okay, you know what, this is an opportunity for us to have a constructive dialogue, and they've not taken the opportunity. And I find it puzzling, to be honest. I think that the inability to kind of take the loss and be a more productive member of the Canadian copyright community is disappointing. I think that's, I just feel that it is at this point unhelpful. Just it's baffling to me.
You mentioned, you briefly in your 101 overview mentioned the government's reforms back in 2012, the addition of several additional purposes within fair dealing, including education. And when you talk about access copyright, not moving on, not adjusting the business model, what it seems that they have done is perhaps, at least at this stage, not yet pursue additional litigation. The defeat at the Supreme Court of Canada was, I think, pretty resounding. But the focus has turned more and more to government, and the hope that government will make changes to the Copyright Act. In a sense, the Supreme Court has spoken now multiple times. Their hope, I think, is that the government will speak and, in effect, overrule the Supreme Court with some new restrictions on fair dealing. Can you talk a bit about your views on how that has unfolded? This notion that somehow access copyright is sometimes loath to talk about what we've seen at the Supreme Court, and instead focus more on the 2012 reforms and suggest somehow that they're responsible for what they see as a fair dealing doctrine that's gone awry.
Yeah, I mean, it's interesting because, we often like to talk about, the dialogue between the courts and the legislature. And I think that out of necessity, that there is that dialogue. And I don't think that it's a bad thing. I think it can be, in fact, quite constructive. I think that in the copyright sphere, we've seen this before, because in 2012, with the Pentalogy and the Modernization Act at the more or less the same time, the Modernization Act had been in the pipeline for some time, and Bill C-32 was in the 40th Parliament, and that died on the order paper when they called the election in 2011. But when the Conservatives won re-election, they just simply retabled it as Bill C-11, which ultimately gained royal assent. And so the courts had to know that this was coming, and I to what extent it influenced their decision in the Pentalogy, their decisions. You could speculate on that, and I will say that I think that it can't not have some bearing, but I think that now the access copyright really, I think, is probably seeing that as an option rather than trying to engage constructively with the copyright community. They are attempting to lobby the government to change the legislation. I do feel that that certainly some of the rhetoric that we're seeing coming out of places like the writers' union and whatnot suggests that there is a bit of a deliberate misrepresentation of the sort of losses that they feel are attributable to fair dealing. And as I mentioned in my commentary in the Free Press and the Hill Times, I feel that is deliberately misrepresentative, and I think that it's, quite frankly, it's a bad faith argument.
Yeah, no, you refer to this phenomena as Goblin mode gaslighting in the Free Press piece. Can you explain what that means and what you see as some of the risks to the copyright policy process here in Canada?
Well, it's funny, actually, because the word of the year, Oxford, it is Oxford, but I think it's the Oxford English Dictionary, went with Goblin mode as their word of the year. It's two words, but they and then Merriam-Webster went with gaslighting. They're talking about sort of society writ large and the sort of the tone of the discourse writ large. And I think that it perfectly applies here, because I think that as gaslighting, of course, is something we've seen a lot over the last few years, especially south of the border. But I think that we're also seeing it here in Canada, is a deliberate misrepresentation of the fact of facts, and delivered in such a way as to make people question question reality, question what their assumptions were. And I think that by this point, the jurisprudence and even the legislation is firmly on our side. By our, I do mean the educational sector and those who would utilize fair dealing. I think that it should be well and truly settled, and yet there are those that are saying that what we are advocating for is somehow wrong. It is, and there's, maybe I'm reading into it too much, but I would say that there's certainly a lot of moral judgment that seems to be placed into it, that we are somehow we're undercutting the sort of the natural order of how this should work, and that's the one part of it, is the gaslighting. And then the goblin mode. Goblin mode is basically to act in a way that is, well, I suppose, goblin-like, but that is self-interested. And that's one of the major aspects of goblin mode, is to act in a self-interested way. And I definitely see that many of these organizations are completely in it for themselves in terms of, and there's a business model to it for sure. Like because it is existential for them, it is very much the epitome of self-interest in terms of being able to ensure that this business model that they have set up continues by any means necessary. So if that means having to gaslight people into believing that unnecessary reforms are inevitable, or that there has been a wrong that needs to be righted, to me suggests that goblin mode gaslighting is absolutely the perfect way to describe it.
Okay, I must admit, it's a term, or at least a combination of terms that I hadn't encountered before. Now, I could certainly understand it. I myself have argued as recently as this week in the series of pieces that I think there's been a real misrepresentation about the state of Canadian copyright law in terms of how it's been interpreted. I think you've done a nice job of unpacking that. But one of the reasons I was really excited to have you come on the podcast is that you serve as the director of the Bitov Law Library at Western University. You're the copyright officer at the university. Can you talk first, I guess, a little bit about what that entails? And then what I really want to get into is a better understanding, essentially on a day-to-day basis, how your experiences and your work accord with the claims that somehow it's fair dealing overall, and what we're seeing take place in universities are all sorts of institutions that are actively exploiting fair dealing and not compensating, rather than relying on a whole range of different licenses.
In my library director role, it's a lot more operational in terms of ensuring the smooth day-to-day running of the law library, as well as doing law legal instruction and stuff like that for legal research, because I do have a JD. And then the copyright officer role, there's a lot more policy and advisory work there, and so ensuring that that our copyright policies are up to date. We are actually currently undergoing a policy review following the York and Access copyright decision, and doing a lot of advising. And that was definitely something that there was a lot of in the height of the pandemic, in terms of advising faculty as to what they could do with their materials, and how they could ensure that students were getting proper access to the materials, and then doing a lot of instruction. I work with the Center for Teaching and Learning for doing working with course developers and stuff like that. So it's a big portfolio. I love it, though. I have to say that the very, very different things, but it keeps it diverse. Part of that role, and one of the really interesting things I was able to do in the pandemic was, Western did join the HathiTrust ETAS. Western was also the pilot site for a controlled digital lending platform that we were offering through through the Ontario Council of University Libraries, so we had our own ETAS platform, and we were the pilot site for it, and so we were looking to work with course reserve. So it was largely for short-term loans and our course reserves, and so that was a really interesting pilot. Unfortunately, we shut it down the same time as HathiTrust, but it was cool to see that we could actually do it and to kind of work through those issues. So I was working with our general counsel as well as external legal counsel to develop those policies. And we are continuing to look at ways in which controlled digital lending could be developed further, moving forward. And there is a lot of work that's being done on that front, sort of behind the scenes, not just at Western, but through vendors that are looking to enable various tools to allow controlled digital lending according to different sort of risk tolerance levels. So I think that has definitely been one of the more edifying and sort of exciting things that I've done in my copyright officer role at Western, is to be kind of at the on the leading edge of getting of developing controlled digital lending as that has moved away from theory and more into practice, because I know there's been a lot of discussion about there's a sort of the theoretical applications of it in the years preceding the pandemic, but to actually be able to be involved in bringing that forward in the Canadian context was fantastic.
Okay, interesting. I mean, so those are some exciting initiatives. Can you tell me specifically about the use of materials, though? I guess, some of the focus has been around site licensing, either in the law faculty or otherwise, transactional licenses, open access. In the world of a law student or working to make materials available to students more broadly, how important is fair dealing as part of that process? How much of it is about the various kinds of licenses that you've signed on to? How much of it is students going out and purchasing original texts, whether ebook or otherwise? Essentially, we keep hearing that somehow it's fair dealing that plays such a dominant role, and I'm curious from your on the ground experience about what it means for an average student or professor in terms of access and use of materials.
To be honest with you, fair dealing, our course reserves. So the course reserves are run out of our user services team, and it's plugged right into our online learning management system. But fair dealing is a relatively small portion of it. A lot of our collections budget has just absolutely ballooned in the last few years since the beginning of the pandemic, because we've had to purchase a lot of materials that are available, that might be available in print as well, that people would have been relying on in course reserves and other physical mediums. And so the move to online and licensed materials has been kind of significant and profound, and also very, very expensive. So there has been a huge amount of money spent there. So I find it kind of very disingenuous. I would think that for a lot of the publishers, yes, they've had to, in some cases, they've kind of had to meet us in the middle a little bit in terms of getting some material online or in digital formats that they might not have otherwise had. The idea that fair dealing is somehow this nefarious means of going and ripping off huge numbers of materials and providing it for free is just simply not true. I I would love it to be that we could have like digital copies that we own and whatnot. But frankly, a lot of the stuff we're just licensing it, and we don't even own it. But it is operationally a lot easier for us. We've also been developing other means of accessing materials, such as open access. Western Libraries has been investing in that. We in the Western Law Library, we've actually just in the last week opened a grant. It's first of its kind, I believe, in Canada, to create a law faculty specific open educational resource grant, and try to encourage those sorts of materials.
I think you've highlighted the evolution that you started to see. Some of it spurred by the pandemic, some of it spurred by digital, some of it by resource constraints that have moved more and more towards various kinds of licensing, fair dealing being viewed. I think it's notable, fair dealing being viewed as a resource intensive matter of clearance. And so the goal oftentimes is to simplify things, and licenses do that. It's just the licenses, it sounds like that you're able to make use of, offer up flexibility that isn't typically found in an access copyright license.
Exactly. And that's the thing that I find interesting, is that it would, from an access copyright perspective, in Canada, we would love to have a Canadian equivalent to the Copyright Clearance Center, where we could go and clear stuff. It's sort of one-stop shopping for that. And access copyright seems like the obvious, that they're in need, like we're in need of a resource and they're in need of a business model. Why can't we reconcile this? It seems like an obvious thing, but it hasn't happened.
Yeah, at least not yet, but perhaps hope springs eternal that we will see some of the changes. Certainly the laws evolved in some notable ways, and I'm glad that you're finding the time to both practice making works available through your various positions, and taking the time during Fair Dealing Week to speak out on some of the policy developments as well. So Stephen, thanks for that work, and thanks for joining me on the podcast.
Well, thank you very much, Michael. I appreciate it.
That's the Law Bites podcast for this week. If you have comments, suggestions, or other feedback, write to lawbites@pobox.com. Follow the podcast on Twitter @LawBitesPod or Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca, or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bites podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.